everyone. So wanted to tackle the issue of escrows with respect to ICOs. You'll see a lot of press recently about certain ICOs missing their target and then sending back what money was raised. And so the question becomes, do you really have to do that? And I think the question is twofold. One, if what you're selling is ideally a security or tantamount to being a security, then under law, if you're doing an all or none or part or none, meaning there's a minimum amount that you must raise, if that's the nature of the offering that you're doing and you fall short of that, legally you have to use an escrow and legally you have to return all the money. Okay, if you do a best efforts, which says I'm going to raise $1 million, no matter what amount I raise, I'm going to keep that amount of money. You don't have to use an escrow, and you don't have to return the money if you fall short. Now that's under Regulation D, and that's also to a lesser extent under Regulation CF. So what happens if you're doing an ICO and you're not doing a securities offering? That ICO or that token is not a security. There really is no guidance, but my thought is this: from a liability standpoint, if I'm going to set out and say in my use of proceeds in my ICO, I'm going to raise $5 million because I need at least $4 million to get this project off the ground. And if I don't make the $4 million, I may not be able to do it. And that's the disclosure you need to put in there from a risk factor standpoint, which is a totally different subject for another video at another time. But the reality is, I think it's best practice if you fall in an ICO, so fall short of where you want to be with respect to what you need to actually get your project off the ground, that I think you have to return the money. I don't think you necessarily need to commit to a part or none or an all or none. You can sell it best efforts, but I think it makes sense to employ at least a segregated account, if not an escrow, up to a certain amount, because in functionality, if you don't raise enough money to even start your project or even get it to a certain point of viability, I think you create a huge liability from yourself, because the question becomes, with all the Bitcoin, all the money that you collect, what are you doing with it? If you can't employ it to get your project to a certain point where there's market progress, where there's actually some asset value behind that ICO, I think you're creating a huge liability. So I'm a big fan of putting a minimum amount. You can do a best efforts type basis, offer some type of minimum amount. Maybe you don't necessarily have to rely, if you're not offering a security in your ICO, on either a segregated account or an escrow account. It's not mandated because there just is no law. But I think from a practical perspective, if you're going to do an ICO and you're going to fall far short and there's nothing you can do to get your project to minimum viability, you have to return the ICO proceeds. There's just no way around it, because at the end of the day, you've effectively collected a bunch of money on a project that ultimately is not going to get off the ground until it obtains additional financing. And granted, you can put risk factors in your disclosures that account for that, but to a large extent, that still creates a liability for you, because at the end of the day, you're collecting money, and what's the money going to be used for, right? You could employ it to the project, but the project may ultimately be worthless. So, I think the best idea is set a minimum floor. It can be pretty low, but at the end of the day, look at what you need to reach minimum viability, and that's around where you should definitely employ, a minimum with respect to raising ICO funds. And as far as a segregated account or the escrow account, it's I get a lot of questions. Well, how do you do an escrow account if you have Bitcoin? How do you It's very easy. I mean, you could open an account or have an attorney open an account at a Coinbase. Have an account on your own and simply assign those rights to a third party and limit control to that third party, and then create an escrow agreement between you and that party. So it's very simple to sort of create segregated accounts or escrow accounts in the absence of paying somebody who allegedly or purportedly specializes in escrow, which really doesn't exist yet in the crypto space. But you can definitely do it with an attorney or like an accountant or some third party through a properly drawn escrow agreement, funds management agreement, and then restricting access to that account. So again, if you have any questions with ICOs minimums and the use of segregated accounts, escrow accounts, give me a shout. Contact me through YouTube here. All right, take care.